legal documents from the franchisor govern all of your obligations for the entire duration that you're involved with the business, and sometimes for longer. They are really the roadmap or the rules of the game, I suppose, for what you're about to go into. Oftentimes franchisors will waive, downgrade, alter, not enforce certain obligations because of the economic conditions, or because they need you, or because they don't want to be rocking the boat at a particular point in the business cycle. But it is not safe for you to rely upon that happening. The disclosure document and the franchise document, which you will be asked to sign, they set out all of the information that the franchisor is required to give you, and they set out all of your obligations. Now, in that documentation will be a very clear statement that says anything that is not contained in this documentation that the franchisor has told you, or that any sales rep or any area master has told you, if it's not written in that documentation, it doesn't exist and you cannot rely upon it. I've had a large number of franchisees come in unhappy, their business is not working, and they say, oh, the sales rep told me I'd make $500,000 a year net profit. If it is not in that disclosure documentation, it is not able to be relied upon, and it doesn't matter what you've been told. There are some exceptions. We can sometimes sneak in through the Trade Practices Act and things like false and misleading conduct, but if you have been told something that is particularly important to you and it's going to influence your decision, you really need to make sure that it's in that disclosure document, because if it isn't, you're going to struggle to uphold that as a representation that you relied upon. The franchise agreement itself sets out a huge number of obligations for you. Every single clause in that franchise agreement is nasty. It contains an obligation for you that you will have to follow. Now, the franchisor may, for a time or in particular circumstances, not insist on that, but you can't rely upon that. The franchise agreement documentation fits into two categories. There is nasty but commercially normal, and there is nasty but commercially not normal. Every single one of them is nasty. Every single one of them contains an obligation for you that you need to be aware of and make sure that you can comply with. The ones that are commercially abnormal, your advisor, if he or she is doing their job, should be saying, look, that's not usually in this documentation and you should look to limit or change that. Franchisors are very reluctant to alter their standard documentation, particularly where they've got a large number of territories, because they want to know that every franchisee has the same obligations. Having said that, there are still opportunities to change the documentation, particularly in times when they rather want you on board, or they're quite keen to expand, or you're buying a territory that they really want to have your skill set in. So just because something is particularly nasty but it's in the documentation doesn't mean that you shouldn't raise it and see if you can get it altered or watered down, or at least a moratorium on it. Moratoriums are fairly common these days. What I mean by that is that the franchisor might say, okay, we want you to pay 2.5% marketing fee based on your turnover, but we'll give you a moratorium for 18 months. So for the first 18 months, you don't have to pay that. It's in the disclosure documentation, it's in the franchise agreement. We'll give you a supplementary deed that overrides that, that says, okay, for the first 18 months, you don't have to meet that cost. So that stuff is always up for negotiation. Most franchisors are very reluctant, but that doesn't mean that you shouldn't ask the question.